So I'm Steve Smith. I'm the moderator of this panel. Every now and then I teach federal courts. It's not my area, but when it needs to be taught, occasionally I do. So I just finished going through some justiciability areas in which I told the class a number of times case or controversy just means the same. It just means the same thing. And then I read Jim's paper, and so I'm looking forward to having a debate between Jim and Caleb. I don't know if it'll be a debate, but to an exchange of views on that and to your questions. So let's go ahead and get started.
Thank you, Steve, and thanks to the conference organizers for putting this together. What a lovely event. I'm afraid I took Mike seriously, so I don't intend really to just restate the paper here, but instead I'll sketch some debts of gratitude and try to situate the paper in some other work I've been doing on the history of Article 3, and then hit a few of the high points of this paper, and then turn things back over to Caleb, whose views I'm very much looking forward to hearing. I'm a bit new to the case or controversy party here, and so it's nice to have Caleb along to show me the way. So debts, I guess my biggest debt runs to my colleague, my collaborator, my co-author Dan Burke, who's with us here today. He's the person with whom I've worked out many of these ideas. We have a paper in press with Yale right now that works through these ideas at much greater length. This is a condensed version of that paper, really designed to be a work in progress, because that work has pretty much been put to bed at this point. Dan's been a great collaborator and a great resource for me. And it's a pleasure to have him here by the grace of his law firm, the grace of the conference organizers who were kind enough to invite him to join us here, and by virtue of his real interest in legal ideas. And in fact, if any of you are interested in a good legal historian, you might try to persuade him to give up law practice and take a crack at it. I owe debt to an old friend, colleague, Bob Pushaw, who first suggested that there might be some differences, relevant differences, between cases and controversies, at least in this context. Others have thought about those differences in other contexts, but Bob was at least an early proponent of the idea that these differences might be significant. And then, obviously, debts to my good colleagues at Northwestern who've been trying to keep me honest on these subjects for some time, and I've heard this paper probably more times than they can count. So how does the paper fit in the work that we've been doing lately? My work on Article 3, I guess you could call, much of it is focused on history. Some people in my corner of the world call it much ado about Article 3. I guess that's not a bad way to put it. Recently, when Dan and I were working on the Scottish Court of Session and the possible implications of the structure of the Scottish Court of Session for the structure of the Article 3 judiciary, we came across this construct of non-contentious jurisdiction, and we were both struck by it. One of my colleagues called it a eureka moment. I think of it more perhaps as a gee whiz moment. But it was kind of a striking discovery, and we've been working for the last year and a half or so to try to work out the implications of that. The larger project, of course, is to try to broaden the conception of the framers, our conception, our understanding of the framers' sense of the judicial power. There's quite an Anglo-centric conception of the framers' world, I think, captured in Frankfurter's famous comment about focusing on the work of the courts at Westminster, which rules out a lot of ideas of judicial power that might have been current in the day. Obviously, admiralty took place somewhere else, ecclesiastical work took place somewhere else, and the Scottish Court of Session was not operating at Westminster. So a number of those possible sources of a conception of judicial power as of the time of the framing are left on the cutting room floor if you take Frankfurter's dictum about Westminster too seriously. So one of the larger themes, I guess, in all of this work is to situate conceptions of judicial power in this broader, more cosmopolitan conception of the framers' world, which included not just common law, but of course equity and admiralty as well, and to think about the possibility that Scots law was an entry point for some of these ideas into the thinking of the framers. This paper, as I suggested, is a kind of more condensed version of one that we have worked out at somewhat greater length, and the focus of the paper is really on these three ideas that are animating features of the Supreme Court's Article 3 jurisprudence, the idea that standing requires an injury in fact as a condition of presenting a case to the court that falls within its Article 3 judicial power, the idea that Article 3 also requires adverse parties, And finally, the idea that there is something called the case or controversy requirement that applies with equal force across all of the heads of judicial power in Article 3. That is to say, treating the case or controversy requirement as a one-size-fits-all requirement rather than one that might distinguish between those things that are called cases and those things that are called controversies. Just to get more quickly into the specifics of our critique of the Supreme Court's the elements, I guess you'd say, of the Supreme Court's approach. And starting with injury in fact, if you look at the history of non-contentious jurisdiction that we sketch in the paper and develop at greater length elsewhere, it's very hard to find injury in fact in many of these original applications for non-contentious relief. And I emphasize the word original because there are a lot of examples of ancillary non-contentious jurisdiction that take place in the shadow of a dispute or the shadow of party adverseness. But it's a different story when the party originally shows up in federal court with nothing but a petition for relief in which there is no adverse party joined, and all you're asking the court to do is to register a legal claim of right. So examples of that are really quite common, and the striking thing is not only that they're common in the early 19th century, but that they continue through the nation's history. So naturalization is one of the leading examples, I think, and there an alien would simply present a petition to a court for naturalized citizenship, and that would call upon the court to conduct a kind of judicial inquisition to determine if the claim was well taken, and if so, would enter an order or a decree granting naturalization, and that would be the end of it. No adverse party was required, and no injury in fact was required either in cases like that. Other examples, prize cases in which there might have been an adverse party lurking, but certainly not one that was required to appear as a condition of the exercise of judicial power. Pension claims were assigned to courts on an ex parte or non-contentious basis. Warrant applications are a familiar example of situations in which party might, often the government, would seek a warrant to conduct a search or to make an arrest or something of that character. Examples more recently include, FISA warrants are a good example today of ex parte applications that go forward without apparent injury in fact or adverse parties. Trademark seizure orders, Crime Victim Rights Act petitions to be recognized as a victim of a crime, applications for judicial approval of immunized testimony, certificates of appealability under the AEDPA, petitions to review class action remand orders under the Class Action Fairness Act. There are a surprising number of these, and about every time I give this paper, my colleagues offer more suggestions. So I hope that at least a few of you whose hands have gone up will add to my list of examples of non-contentious jurisdiction. In any case, with the sheer number of these instances of non-contentious work, it's very hard to say that an injury in fact is required as a condition of invoking the judicial power in every case. With respect to the adverse party requirement of Article 3, I would say much the same thing, that the existence of non-contentious jurisdiction in the absence of party adverseness is very hard to square with the notion that there's a thoroughgoing or full-throated commitment to adverse parties. And you see it actually rejected in very straightforward terms in a number of early and perhaps overlooked cases. There's an interesting case involving a naturalization petition in which Chief Justice Marshall participated. And the argument from the opposing party in a contest about whether someone was really naturalized or not was essentially that was just an ex parte proceeding. There was no judicial power invoked there, so there's no preclusive effect that should attach to the naturalization decision. Marshall swept that argument aside and said this is a judicial work, and the order is an order of a court of record binding as any such order would be. And so no requirement that adverseness ground the power of the court to decree in those kinds of cases. You see the same thing being said by Justice Story in the admiralty context. So Story was obviously quite learned in civil law and understood the civil law origins of admiralty practice and understood that party adverseness was not an element that was required as a condition of decreeing good prize. The captors bring the vessel to port. There's an established procedure for taking depositions and determining what the facts are on board the vessel, whether the vessel is good prize or not. And if it is, the court decrees, even if no adverse party shows up. And Story was quite clear that adverseness was not required, that that's an artifact of the common law world, and that in the civil law world where he was operating, the court conducts that inquiry as the guardian of all the interests. In other words, a characterization of the judicial role as inquisitorial rather than the passive adversary judge that we've become so familiar with. Finally, with respect to cases and controversies, the definitions offered of the term case by Story and Marshall, I think, are quite compelling. They both define the term back in the 19th century as a situation in which a party asserts his rights in the form prescribed by law. No requirement of an injury, just a requirement of an assertion of rights in the form required by law, no requirement of an adverse party. It's framed, in other words, to capture a practice with which both justices were familiar, the practice of non-contentious jurisdiction in naturalization and in admiralty and in other proceedings. And so to say that cases require injuries in fact is really to depart, I think, pretty significantly from that conception, the early conception of the meaning of that term. So that's enough for sort of the negative case against the Supreme Court's originalist arguments in favor of its case and controversy learning. Something that I didn't do in this condensed version of the paper, but that we do at somewhat greater length, is to try to offer some suggestions about what a reconstructed case or controversy requirement would look like. And actually, one of the things I quite like about non-contentious jurisdiction is the number of problems in my little Fed court's corner of the world, the number of problems that the construct can help us solve. So if you were reconstructing, you might say that the term case encompasses both disputes between adversaries, the familiar kind of judicial power, and non-contentious submissions, so that you could encompass both kinds of judicial function under the term case. But controversies really do require a dispute. The term seems to suggest the existence of a dispute between adversaries identified in Article 3. So you might draw that distinction and say that the power of the federal courts in cases is broader than that in controversies, and that might help you to explain a number of things that previously have seemed somewhat anomalous. One of my favorite examples is the example of the probate exception, which is kind of the one of the members of the old curiosity shop of federal jurisdictional lore, and that is the idea that federal courts don't hear probate matters. And my suggestion is that they don't hear them because most probate matters began as ex parte common form submissions for the admission of a will to probate without the identification of a party opponent. When a dispute showed up in the probate court between parties of diverse citizenship, that dispute was appropriate and was actually adjudicated by the federal judiciary. So that just means that federal courts can administer the law when it's federal law, but they can't administer state law. They're limited to the adjudication of diverse party disputes and other kinds of disputes between the parties identified in Article 3. And I'll leave it there and look forward to all your comments. Thank you.